Hello, ladies and gentlemen. So our panel A will be moderated by Professor Ian Warden. Ian is a sought-after researcher, writer, and speaker. He's Professor of Information and Communication Law and Director of the Centre for Commercial Law Studies, Queen Mary University of London, my boss. So the floor is yours, Ian.
Thank you very much, and good morning, everybody. We've obviously had a very good start to the day's proceedings with a very interesting session. Zeke, in particular, as an alumni of mine, it's very pleasing to see the work that he's been involved in, and we, in fact, at the Centre for Commercial Law Studies have contributed to the development of that policy with regard to AI governance. So we feel very much a part of that whole debate. I'm very pleased to be moderating this session this morning, and we've got 5 speakers this morning, so I will not delay any longer, and I'll first of all hand over to Professor Weidong Ji, who's a founding co-director of APELIA, who will be speaking about the domain of computational law. Over to you, Professor G. You're on mute. Okay.
Hello, everyone. Let me share my slides. Okay. Is it okay?
You could perhaps put it on.
Yes. Okay. Sorry. Okay.
Perfect. Thank you.
In recent years, the expanding application of AI in China's legal field has prompted increased attention to the relationship between the rule of law and AI, and to consider computational jurisprudence as an interdisciplinary discipline with an independent system in the legal field. My presentation today is to position computational jurisprudence in this context, explain the origin and the research areas it would cover. Also to examine the impact of the Internet of Things, big data, and artificial intelligence from the perspective of the modernization of China's national governance system and construction of the rule of law order. The context of my presentation is divided into 5 main parts. First, I would like to analyze the problematic situation and show that the significance of computational jurisprudence is to overcome the subjective arbitrariness and uncertainty of the state power. As you know, rule of law has stood as the pillar in modernizing China's system for good governance, since power structure is justified when it is able to strictly conform with legal rules so as to restrict its arbitrariness and preserve a harmonious and steady society. To this end, law requires a neutral, objective, just mechanism for decision-making and implementation, and needs to raise the predictability of judicial process to the extent possible. In the process of modernization, in order to limit the discretionary power in the application of law, people try to reconceptualize the empirical wisdom of law with the analytical framework of natural sciences, especially mathematical thinking methods, and try to establish an axiomatic system of norms and clarify the relationship between various rules by means of syllogism and subsumption to ensure rational and just judgment or decision based on conceptual calculation and weighing various interests. This method comes from rationalism with widespread and profound application. This presentation will first observe, respectively, the two distinct thought processes. One is rule-based, and the other is science-based, in overcoming the complexity and indeterminacy of law, with emphasis on analyzing the history and the future of computational law from Leibniz's attempt to express legal knowledge in a mathematical way to today's digital boom, within which various thought experiments and trial and error exemplified by the application of algorithmic monitor, geometric models, machine thinking, and symbolic operation to law were performed. Based on the ongoing discussion and popularity of information technology, I will then explain and analyze 4 fields derived from the computational law: jury metrics based on case data, popular since 1916; computerization of legal reasoning since 1970; legal informatics since 1980; and cyberspace law and the development of the internet since 1990. In addition, since 1916, countries around the world have started to realize that AI is not just a matter of computer science. For AI to reason and make a judgment like a human, it has to learn the complexity and indeterminacy of human beings, which means social values are bound to be taken into consideration by AI. At the same time, it should also provide an ethical framework for algorithmic design to prevent algorithmic bias, indicating that there was an ethical dimension to computational jurisprudence, fifth dimension with transcendental character, which requires careful study. Then I'll go to the response of law. At the request of an ancient Roman lawyer, Cicero wrote a Topica, which provided technical guidance and a list of important topics for judicial practice. This list, with a fixed format, could be applied in 2 aspects. One, the argumentation within a certain topic, together with its components or things directly related to the topic. 2, the argumentation based on external authorities or conditions without a direct connection to the topic. Therefore, Cicero believed that in essence, topics provided a process for people to find processes for judgment making. Topics and case history were often linked to probabilities So they could also be deemed as a primary calculation of probability based on experience and wisdom. The axiomatic system of legal doctrine points to the fact that it is already invented in Savigny's early discourse on the technical explanation of law in geometry, reasoning, and calculation with concepts. This is particularly evident in Puerta's conceptual jurisprudence. Puerta believes that lawyers, whether in theoretical thinking or legal practice, must conduct a pure logical deduction according to scientific principles. Also, legal rules should be subject to the concepts within a logical structure. The concept of hierarchy is a way to achieve the goal of legal domination of society and to achieve legal certainty, clarity, and justice. Rudolf Yelling, an early advocate of conceptual jurisprudence, imagines a conceptual system of law as a table of chemical elements that can be arranged, paired, combined, and reorganized in a logical manner. However, his opinion changes drastically in the early 1960s, stressing that concepts are derived from reality rather than the other way around, and experience outweighs logic when it comes to making judgment. Then I'll go to response of the science.
Just quickly want to say we have 5 minutes, I'm afraid.
Okay, thank you. Since the 17th century, the attempt to resolve problems concerning law and justice by methods of sciences and techniques have been increased frequently. We can find, for example, the utilitarian philosophy Benson believe morals were calculation of the total amount of happiness. Try to put morals under the charge of mathematics. Benson regarded the greatest happiness for the greatest number as the basic principle of legislation. And Leibniz was the first person to see the rational law as the product of modern science. He tried to remove and restructure the jurisprudence by means of mathematics, enable all contents of Roman law to be conducted from extremely simple basic principles using a logical method of transmission. In the 20th century, we can find that in the United States, spread by the slogan of jurisprudence as science, and there's an empirical scientific approach to be studied in the United States very broadly. And then I will go to the digital information communication technology and computational law. Since 1946, ICT has been constantly developed and popularized. And after 1995, computers have made Internet of Things and Internet intelligent and network society with reality. So we can find the three waves about the computerization of legal reasoning. For example, we can have a look at the computerization of legal reasoning and the smart court experiments in China. The attempt to computerize legal reasoning should be marked by a representative paper published in sorry. Because the strong support of administrative power, the software development and application of legal extractor system, and as well as the construction of smart courts, have made great strides in China. But because the study and operation techniques of legal reasoning and its computerization are not mature and detailed enough, which may eventually lead to prevalence of traditional model of AI plus summary trial lowering the level of legal thinking. Therefore, the important goal of computational law in China is to improve the mechanism of smart legal reasoning, including sorting out professional legal knowledge, constructing computer language expression, and semantic web, discovering the relationships between concepts in lots of data to establish lightweight and ontology guided machine learning designing, and the future of training data. As the conclusion, I would to drive your attention about the full coverage of digital and full coverage of law in China today. And these two full coverage actually overlapping together. And so our goal is to develop the AI algorithm of legal reasoning. And AI governance and the international rules is the focus of the AI governance studies. The policy of Chinese government is to keep a balance between individual rights guarantee and the digital economy development. So that's the situation in China today. I'm sorry, because of the time limit, I would like to end my presentation here. Thank you.
Thank you very much indeed. That was extremely interesting, particularly the history, I must say. I'm fascinated by the number of historical figures that have been interested in how law can be digitized or computationalized in some way or another. So thank you very, very much for that. I will now hand over to, I understand that Professor Ringer is unable to join us, so I'm now handing over to Alessio Azzuti from the University of Hamburg in Germany, who will be talking to us about why the black box matters. Alessio, thank you.
Thanks, Professor Walden, for the kind introduction, and I'm starting the sharing. And thanks to all the organizers for inviting me to participate to this exciting event indeed. All right. Can you see the slides?
Yeah. Thank you.
All right. Yeah. All right. Let me first start introducing the motivation that led us to enter into study. We were mainly motivated by the observation of the spectacular achievement in the technology of machine learning as well as big data, paving the way to achieve really autonomous AI agents in many fields of application. And on the same time, we were triggered by the observation by antitrust literature, and especially regarding legal and ethical issues that may arise anytime we need to assign liability for AI wrongdoing or crime. In this paper, we mainly claim that indeed, given the increasing autonomous nature of AI trading systems, financial markets may be exposed to new source of risk, especially in terms of market abuse. And because of that, we may have a problematic application of established legal concept of liability, such as intent and causation, and these expose an outdated regime of market conduct supervision, especially regarding market surveillance and other enforcement mechanisms. Well, the financial industry has been undoubtedly pioneer in adopting AI solutions since the time of of expert system. Those AI approaches that are more deterministic and because of that constrained by the specific human knowledge in the domain of application. Whereas with the progress in machine learning methods, we are now able to achieve algorithmic trading system with increased autonomy versus human control, and even equip them with self-learning capabilities that we will explain in a minute. Why it's hard to study the implication of machine learning tools to capital markets? Because they are called mainly to operate very complex tasks that require, again, specific domain knowledge. Algorithm trading system should be understood not just as a single algorithm, but rather an ecosystem of algorithms. And also the methods, machine learning methods often used can lead to the so-called black box problem. The black box problem refers to an inability also for the human experts that are developing and using the machine learning methods to predict the outcome of their methods, of the AI, or even to understand and explain ex post why a certain outcome has been reached by the machine. Moreover, AI trading being operating in digital environments, can be hard to disentangle the operation of a single AI because is called to interact with other agents. Well, from an analysis of computational finance literature, we find that we are really close to approximate autonomous AI agents also for financial tradings. And indeed, as an emerging machine learning paradigm, it seems that deep and reinforcement learning is going in that direction. Thanks to this machine learning paradigm, we can now create AI trading system that can act independently on markets, learn by own experience from the outcomes of their decision, while also pursuing a predefined objective. In a financial market context, this will be probably a profit maximization goal under some risk control. This, in a sense, also recall us the way that traditional human traders also are called to operate and learn from their experience of market activity. While we recognize in our paper that there are three basic scenarios involving algorithms that disrupt markets, we focus on the novel scenario, which is the autonomous misconduct by AI systems, whereas the previous two cases are already well known by enforcement authorities, although they may still create problems to effective enforcement. We focus in our paper on two market abuse risks. One is market manipulation, defined as any attempt to deceive other market participants or to secure a price or a financial position, or to initiate a price trend on market, again, to gain from triggering other participants in trading. We claim that indeed AI may be used to learn, and AI alone may autonomously learn and discover manipulative strategy as an optimal and rational strategy, regardless of any human intent. Interestingly, computational economics is providing first evidence of the relationship between algorithms and market manipulation. For example, Mizuta 2020, Martinez Miranda studied the relationship between reinforcement learning agent and their ability to autonomously discover market manipulation. And we basically conceptualize possible case studies, and we find and we believe that indeed AI may serve the purpose of manipulators in those deceptive order-based frequency strategies like spoofing, but also for more aggressive strategies like pinging, and especially for the AI can be really used for optimized cross-market and cross-asset manipulation strategies, which are also the most difficult for prosecutors to detect and enforce. Looking at the future, AI could also be used beyond the capital market itself and engage also in information-based manipulation, or every time it's able to operate through the web, and so mislead through false information other investors. This is also the first study that tried to understand the feasibility of tacit collusion to occur on capital markets in a critical way. Whereas other studies just name the risk, we try to provide more reasoning and economic evidence on that. Indeed, there are already some in-lab experiments that show the ability under very simplified settings that reinforcement learning agent can lead to some form of coordination. And although this study tried to shed some light on AI ability to reach collusive outcomes, is still uncertain what the role of communication between different algorithms should be. As case study, we leveraging on the economic theory, explaining what are the facilitating market factors that lead to collusion. We believe that risk may arise especially into market segment. One, quote-driven markets, because of the critical role played by some dealers, and for similar reasoning, we believe also this may also happen in financial benchmarks. Well, if AI can autonomously enter in a manipulation, can lead indeed to new questions, and relating especially to the safe application of traditional liability concepts such as intent, causation, negligence. Well, these problems were already evident with more deterministic system. We believe that AI agency can further frustrate the ability of the law to regulate effectively AI behavior on financial markets. And indeed, AI agency can frustrate both the compliance and the enforcement of market abuse regulations, because mainly distinguishing whether AI misconduct results from an intended consequence or inspired by some prior human intent or just an autonomous AI decision would be extremely challenging, not only internally for investment firms, but outside the world of investment firms, and especially for the case of enforcement or other market players called to detect and surveil markets. So the main takeaway of this analysis is that we may find extremely hard to achieve effective transparency and auditability for specific machine learning methods. And while the law, especially in the UK, require for strong form of explainability, both to comply and to achieve effective deterrence in the enforcement, de facto, because of the current legal system and also the supervisory structure itself, this strong form of explainability is only addressed in a limited way. We think that this, and especially the black box nature of specific machine learning methods, can then frustrate firms' ability to comply with the law, can hamper the safe and legal implementation of specific high trading strategies, and overall impair financial innovation. In the paper, we discuss several proposals made by different scholars, but we reject also some of traditional form of regulation, like a complete ban or strict liability rules. And indeed, and we also reject that, at least at this stage, the idea to grant legal personhood to AI. We rather would suggest, if we want to keep safe the current legal system, and we provide indeed some guiding principle for better regulation of AI. The first, we should ensure traceability along the AI supply chain, maybe applying the so-called the human in the loop approach, which seems to be confirmed by many soft law documents at the international level. Basically, we should looking at the future, abandon command and control approaches and try to expose more adaptive form of regulation. This could be achieved by both ex ante and ex post regulatory approach. Ex ante, we could enhance AI transparency, for example, by testing regimes before that algorithms are actually put in the market. Although these open new important question relating, for example, the scope of testing itself. And indeed, there might be gaps between what is simulated scenario and what are the real market functioning. Exposed indeed to enhance AI auditability, there are many proposals, for example, to try to achieve through supervisory technology, real-time market surveillance mechanism or to enhance reporting arrangements to allow for a constant and instantaneous communication supervisor supervising. And from a RegTech side, there might be also the idea to explore of machine readable regulation. And overall, this suggests that in the future, we may have a greater scope for both supervisory technology and regulatory technology. To conclude, I want to just leave a final comment. I think that the main contribution of the paper is, first of all, the interdisciplinary character, bridging together law, finance, and computer science. And indeed, to face increasingly complex questions, we argue that we need more collaboration between different scientific communities. And yeah, thanks for.
Thank you very much indeed. Very interesting, very clear presentation. Very different. You're looking to the future in terms of financial regulation, whereas the first speaker obviously was looking at how we got to where we are today. So I'd now like, if people have questions, please use the chat to the question answer application to ask questions, but we'll continue with the presentations at the moment. And I'd like to hand over to Dr. He from City University of Hong Kong, who's going to talk about the regulative framework for AI and copyright. Dr. He, thank you.
Right. Thanks very much, Professor Walden. You're actually I'm very happy that we have many IP experts in the field. So I was thinking that, because people are talking about technologies, and now I think, my topic will sort of trigger some of the interest, and especially I would like to hear some suggestions from you and Professor and Tang Guan Hong, right? So, okay. So it's very simple topic. It's about how we can regulate the challenges that we're facing in terms of what I call the AI copyright crisis. So in here, basically it concerns like 5 parts of my presentation. So the first part is about, everybody knows that AI creativity, which concerns the legal determination of the things that AI could generate, right? And the second part is about enforcement. Currently, I think there is a hotly debate issue about whether we could use algorithms like in the future in technologies to detect and about copyright infringements. And the next part is about the exceptions which relate to data mining and using AI and an algorithm. And my conclusion is that law is not enough, and that probably we need have more comprehensive regulatory framework to do that. So AI technology and its application has profoundly challenged and the ecosystem of the copyright and also the traditional copyright jurisprudence. The first challenge is the concept of copyright itself, right? So because according to my previous research, AI can now generate content similar to human expressions, such as paintings, articles, poems, and music. So then the 2 major issues here are whether we should give AI legal personhood so that it can enjoy copyright over its creations. And the second, if not, then the next question is whether the AI generated contents are copyrightable and whether these interests can be assigned to a specific human person, right? So for the first question, it is highly doubtful that we should do that, because for the second question, then I conclude that the copyright theory requires inevitably a human author, and recognizing human as author is intrinsically in conflict with the copyright jurisprudence. So for example, in author's rights jurisdiction, the theories related to originality, moral rights, utilitarian and personality justifications of copyright are all linked with a human author. So the conclusion is either we need to identify a human player inside as an author, or we need to find an alternative solution that could bypass the author issue. So we don't have to recognize them as authors, but we need to figure out a way to give interest to some people who contribute to the process, right? So the next is what we call the filtering technology employed by content platforms, which concerns identifying copyright infringement using technological means. So users uploading infringing contents to platforms is a very complex problem today, especially for those partial borrowing cases. So due to many reasons, targeting users is deemed not a good idea. Many copyright owners have turned to the platforms for secondary infringement as a solution. But they're important to our digital economy. So the solution proposed around 2000 is the USDMCA safe harbor rules that aims to exempt platforms from secondary infringement claims if they followed certain procedures. So as the number of upload is huge and beyond their handling, so this seems to be reasonable to a degree. But soon humans are replaced by technical means such as algorithms. So even though platforms are not obliged to do so, but because platforms want to attract copyright owners, and that will also help to reduce litigations, which are costly and time consuming. So they employed technical means to screen out all of these possible infringements. And technically, machines are faster and sometimes more precise than humans. So however, the downsides of the future technologies are, first, it has the potential of making wrong decisions, but it will get better. And the real threat is to the fundamental rights embodied in the copyright law jurisprudence, such as the freedom of speech and fair use, as copyright also serve a public purpose of delivering speeches and disseminating information and knowledge. But different countries, even courts, may have different understandings about what could be considered fair. So algorithm taking over will result in a scenario that the platform in practice has taken over the role of the court in deciding fair use cases that cannot simply be decided by percentages, right? So because that is what algorithms do, like 80% is not, is of course infringing, so 20% is not, something like that. So the algorithms are not qualified to make such decisions, but some believe that the negative sides are trumped by the positive side. So they advocate filtering algorithms such as what we see in the EU, right? So the last example I would like to share is the use of data in AI analysis. So digitalization and IoT have turned everything into data. So some of this data collected for data mining contains copyright works. So the problem is that it is impossible for the AI user to obtain license from each and every copyright owner for their pieces they use. So when the data is huge. But for this kind of application, a nearly complete data set is indispensable. So many have suggested that at least copyright law should give an exception on or fair use for these kind of uses. So I have finished a chapter about proposal for China, but other jurisdictions have taken the lead in creating rooms for AI analysis of data in their copyright laws, such as the EU and Japan. The US fair use model is already flexible enough to cover it. So I have demonstrated in the previous slides that 3 challenges faced by copyright law and our current legal solution proposals. But law is definitely not enough. For example, for AI creativity, we could still figure out a way to provide them with legal protection, not either proposed by someone using the neighboring rights model. But there are some problems that cannot be fully addressed by the law. For example, the dilution problem is the most urgent one, as it concerns the powerful AI that could generate contents much faster than humans, and people would not be able to distinguish the two. So how can we make sure that the market would not be overwhelmed by AI creations? For filtering technologies, making them mandatory will bring in the issue of cost, and also it will cause concentration, as all the titles are gathered in several big platforms, and that will in fact give them superpower to control speech. And there is the black box issue mentioned by other speakers as well, and this mechanism is sometimes abused in helping government censoring contents in the name of fighting piracy. So for data mining exceptions, providing users an exception is not going to solve the access problem. Without proper channels, there's no way for one to access restricted data controlled by big companies. So the future plan that I propose, which is the last slide, is a regulated framework that consists not only legal solutions for the dilution problem of AI creativity. We can set technical requirements such mandatory digital signature that force the AI creations to reveal themselves in the market. For filtering technologies, even though the focus is mostly on percentage of borrowing, but as it concerns free speech, the black box issue must be solved at least to a certain degree. The algorithm should be disclosed to a degree. Some will argue that market will force the platforms to improve their algorithm, but the concentration will stop that from happening. So the disclosure will provide more information to the users and help them to decide whether complaints are necessary, and this could avoid censorship filtering in disguise of copyright filtering. So there must be a remedies via which the users could challenge the decision as well. In terms of data mining, the exceptions provided by copyright law cannot solve the access issue as data is controlled by companies. So I got an exception, but I cannot get to the data. That is nothing useful in there. But as the focus is copyright works rather than other types of data, so data holder cannot be forced to open data widely because they do have the rights. A better mechanism is to set obligations to cooperate, leading by the government, and limited requests to reasonable ones, or promote proprietization so that people can freely, make transactions. As the data holders do have corporate protection, it would be better if designated institutions such as a collective society could collect a sum of money that could compensate expenses related to facilitating users with regard to access to data and maintenance. Of course, the eligibility determined by the exception should be extra clear, and the courts should provide assistance in confirming that. So my conclusion is that in an AI era, law as a regulative measure is not enough. Not only technical measures could provide help in regulating the AI copyright crisis, but we also need to consider the industrial norms and market power and come up with a comprehensive regulatory framework. Thanks for listening. So this is my presentation. Thanks.
Thank you very much indeed, Dr. He. It was a very clear presentation and a very interesting topic as well. So we're covering quite a range of issues within this particular session. But again, I'm going to move on to Guan for the last presentation before I open up to questions. So thank you again for your presentation, and Guan, I'll hand over to you to your presentation. Thank you very much. We can't hear you, Guan. Sorry, Guan, we can't hear you.
Okay. Hello, can you hear me now? Okay. I'm sorry, my slide doesn't work. And Chen, if you want, you can put up my PowerPoint, which is really only 3 slides. AI is everywhere, whether you like it or not. It's hard to find an industry that hasn't been affected by AI nowadays. As my peer panelist, Professor Ji Weidong, just pointed out that the wide applications are challenging ethical, societal, regulatory, and legal norms, and are creating fundamental concerns. For example, in a very popular scenario of self-driving cars, the UK has just decided to allow them on roads later this year. So the question comes, what if a self-driving car crashes and injures a third party? The current framework places liability on a single insurer. There's a confusion regarding the scope and the nature of responsibilities, as well as liabilities. Particularly, how should the risks be fairly mitigated and also be reallocated when AI caused the accident? Of course, we say initiatives are being suggested and promoted by national and international actors. Major players, however, including the UK, are taking a very reactive approach in this regard. For example, as Dr. He just presented, that currently an AI system is the subject matter of IP law, which means that AI has no rights to ownership. Ownership is a right that may only be claimed by a natural or a legal person. Lacking legal rights means that AI has no legal liabilities. Together with my awesome teammates, Greg, Hong, Chen, and I argue that it is time to adopt a proactive approach, because reactive or proactive, as Shakespeare would agree, that is a question. That's why we are here, to talk and to communicate and to debate. And my teammates and I think it is the right time to consider AI as an artificial person, which is an entity recognized by the law as a legal person. Taking history as a mirror, we examine the development of a company and review how right and duty-bearing entity recognized as legal person. And we analyze the resemblance in line with the evolution of AI. Our findings are very straightforward and include, as you can see on the PPT, the following points. Firstly, we think that this is a demand of commerce. We all know that commerce is important. It helps to better satisfy human needs and human wants. And companies' legal personality arose from the demand of commerce and greatly benefited the production, collection, and distribution in commerce and in society. Expecting the AI-related productivity could expand the UK alone economy by 613 billion in 2035. We think that such demand and benefits have been seen in the AI economy. Adopting AI artificial person system will clarify responsibilities of stakeholders, like Professor He just mentioned, and also will make litigations and remedy easier. And our second finding is that the infrastructure and the wider utilization in society actually promotes such call. Infrastructure is key, both theoretically and practically. Companies' legal personality was promoted by thorough research, including the legal relationships amongst various legal subjects and the wider application in society. We think that also echoes the current situation of AI. We have comprehensive studies, advanced technology achievements, and we have very wide applications of AI. If we say the Industrial Revolution in 18th, 19th century resulted the surge in productivity, allowed the development of legal personhood for company, and we would say that the fourth Industrial Revolution, in which AI plays a key role, would result eventually the recognition of artificial person for AI. And the last findings we want to put forward is that it's also an answer to the call for advancement of cross-border movements. The development of company legal personality has brought countries close to one another, and the world has become one big market, which in turn promoted the consensus of company legal personhood. The nature of AI technologies is cross-border, and the consensus will be reached one day, we believe, and will help not only the development of the technologies, but also the AI-related various stakeholders. And of course, we see the initiatives both nationally and internationally. For example, the EU regulates risk of AI and proposed to create specific legal status, a new one. It's called electronic persons for sophisticated autonomous robots. And we also say that Russia just proposed that robot agents may own property and assume obligations and have the right to sue. However, those proposals are flawed, and without looking into the theoretical provision for AI legal status, such proposal wouldn't be in international consensus in our view. We believe that the mentioned situations of harms or losses caused by AI should be clarified in legal liability. And a system of artificial person may be the answer. As John Dewey reminded us in 1926, almost a century ago, that for the purpose of law, the conception of person is a legal conception. And put roughly, person signifies what law makes it signify. Indeed, to conclude, we think that conditions are ripe for taking a proactive approach to AI legal personhood, which of course call for basic and multidisciplinary research and discussions and constructive dialogues and conversations. That's what my short presentation intends to initiate. And also that's like Professor Spiros Maniatis said that this year's APELIA conference aims to promote. Thank you very much, Ian.
Thank you very much, Guan, and thank you for a very timely presentation. And it was particularly apposite following on from the previous speaker who I believe was saying he didn't believe in artificial personhood. So there is at least an issue for discussion there. In terms of questions, we've had a question from Shazia that says, what's the purpose of creating an artificial intelligent legal person? Is it not ensuring human agency and responsibility? Could it be not done in another way? So Guan, if you could just sort of, how are you linking the creation of a legal person to responsibility and human agency? And then I'll hand over to Dr. Haig just to give his response to your proposals. Thank you.
We're not calling for creating an artificial personhood for AI for the sake of it. As I briefly mentioned, that we think that by granting AI legal personhood, then you will be able to clarify the responsibilities of different stakeholders involved, and therefore the liabilities will be clarified and clearly defined as well. So in that case, if there is a damage, if there's a loss caused by AI, it will be easier and also logical to litigate.
So the proposal would be easier to find out. It would be easier to find somebody against whom you can enforce remedies.
Exactly. Basically, it will help to clarify responsibilities.
Okay. So responsibilities is one aspect, and rights is the other aspect. So Dr. Hay, would you just like to comment on Guan's proposal?
Okay, so actually, I'm not against the idea of having legal person. I'm just saying that, there are a lot of people saying that there is a lot of risk of doing so, especially the recent paper published by Simon Chesterman just in ICLQ, right? So that is a very good paper. and that is a good demonstration that, how the debates will go on. So my point of view is that, especially in terms of copyright, the recognizing, AI as a creator or an author is against the fundamental design of copyright law. So that is a problem. If we recognize it, then there will be a lot of new problems that coming up that we cannot, to sustain our copyright system, because we build out all our theories on, in incentivizing people to create utilitarianism, like people, got their, connections with the works. So how we can, prove that, justify that by saying that the machines will have the same kind of contribution to the work. So I'm just saying that, machines can generate a lot of things, but we don't necessarily have to recognize them to that degree. We just say, probably anything that they create is still related to human investment. So people invest in creating the machine creating the things based on, previous human intellectual creations. So in a way, the things that they generate is connected to a human. So in either way, we can figure out a design that could bypass the theory by recognizing that machines can be an author. So why we just pick the difficult way to do that? We could always pick, a simple way, at least to solve it at the moment. So maybe, in the future that people, machines can talk to us and understand us, can show their sentimental feelings, they have pains and things like that, then possibly at that time, we will have different thoughts. But at the moment, I think that machines are just one of the tools that we use to create things. And the things that they create are eventually linked to human. So we don't like to do that because it's unnecessary. That's my point of view.
Thank you. Professor G, you outlined 4 key disciplines of computational law, but one you didn't outline was robotics and the notion of an artificial person. So I'd welcome your views on this debate about the need to create an artificial person.
There are 2 very serious problems in computerization of legal reasoning. One is the simple grounding problem. The other is the knowledge storage problem. And for legal reasoning, the essence is value judgment and weighing different interests. So it's very difficult to handling this kind of things by logical jurisprudence only. In my opinion, we can learn from the traditional topical ideas and make systemize the topics and make the value judgment based on the principle and make a systematic of this principle and find the centricity of the topic. Then we can improve the algorithm of legal reasoning. That's my point. Thank you.
Thank you very much. And I think it also brings into question the comments that made about market manipulation by Alessio, because, and this is a question for you, Alessio, is you talk about problems of causation and problems of culpability. I mean, the law has ways of dealing with that. The law can simply say, like in product liability, strict liability, you don't need to worry about culpability, and presumably the law could deal with the problem of causation as well. Either make everybody liable or the whole supply chain liable, as the GDPR does with regard to breaches of data protection law. So just interested in your views on this question of the artificial person, whether the artificial person helps solve the problem of market manipulation, culpability and causation. Thank you.
All right, thanks, Professor, for the question. I'm not by default against the idea of granting legal personhood to AI, although I think that we should really have clear understanding of what are the use cases out there. Because, for example, AI systems like algorithm trading system can pose very different questions from robots. So, and indeed, also the use of AI within internal to an organization also pose different questions from an AI on the market, acting, interacting with third parties, and so on. I also think that we should also try to disentangle the criminal and civil liability dimensions, because while on a civil side, I may justify easier the idea of a legal personhood than to create easier remedies whenever an harm is manifest. On the criminal side, I think rather we should still have tools in place that let us understand what the single contribution of the individuals behind the AI development. And then just to conclude, beside the legal aspect, there are also policy dimensions here, but those depends on our understanding of the world and what is our normative approach towards society and its future. So the question is, are we really safe with the idea to granting legal personhood to AI in all the field of application? Thanks.
Thank you very much. That's a very good point. We tend to sort of frame the debate as yes or no, but of course the answer is it depends, which as lawyers we should be used to knowing that that's the answer to every question. And one of the issues that has always intrigued me since Lawrence Lessig published his book Coder's Code, which is very close to what Professor G was talking about, is how do we account for language and discretion in a code-based system, essential to a legal system, but very hard to replicate in a code-based system. So thank you everybody for your very fascinating presentations. As chair, I have to bring this session to an end because I've been told I have to bring this session to an end. So thank you everybody for your participation, and I'll hand back to the conference host.
Thank you.
Thank you so much, Ian. That was a very interesting session indeed. And thank you all the speakers. And we were starting our panel B at 11:30. You don't have to sign out, just stay in and we will bring you back.
Thank you.
Thank you. Bye-bye.